Have you ever wondered what's in your mattress or the pillow that you sleep on every night? Foams, gels, springs, must be some sort of soft fabric, right? Hi, I'm Maggie with Legal Label, and many of you may be familiar with law labels that come on your bedding, furniture, or stuffed toys. At the turn of the 20th century, mattresses were commonly filled with cotton, curled animal hair like horse, cattle, or hog, and kapuk, a fiber made from the pod of a tropical tree. Other ingredients included burlap, wood shavings, feather and down, felts, husk, and wool. Unfortunately, though, not all of these fibers were new or clean. To protect consumers from unknowingly purchasing unsafe or unsanitary products, states began passing tagging laws, identifying the contents of all bedding products to protect consumers and distinguish reputable manufacturers from unscrupulous ones. These labels soon became known as law labels. Maryland passed the first labeling law of its kind in 1906. Several years later, in 1911, in the aftermath of the 1906 earthquake during the rebuilding process, California passed the Mattress Inspection Act, mandating that mattress labels disclose all hidden filling materials. Ohio enacted similar legislation in 1911, and others quickly followed. By 1923, 27 of the then 48 states had adopted bedding regulations. In 1933, according to William E. Quinn, director of the bedding division of the New York State Department of Labor, the law grew out of the protest of workmen in various mattress factories who saw the leavings of their lunches being swept into a pile of prospective stuffing. The term, "do not remove under penalty of law," that has been used for decades on law labels, was intended to protect consumers, but often became confusing. The penalty, of course, was not meant for the consumer.
But there's no doubt this label is meant to be taken seriously by manufacturers, because behind this tag is the continuous effort of the industry to drive the legislation to protect the consumer from fraud and unsanitary materials. New York legislation summarized that consumers are entitled to buy and use upholstered furniture and bedding secure in the knowledge that the articles purchased are free of pathogenic organisms, vermin, and filth, and the nature of their content is as represented by the seller. In New York's heyday, under William Quinn, there were 25 inspectors pulling any suspicious-looking or off-smelling items in the state's 30,000 factories and retail stores. Over 2,000 samples were analyzed, and 27% of them were tagged incorrectly. These articles were seized and ordered off sale. In December 1915, 39 mattress manufacturers gathered in Chicago, forming the National Association of Bedding Manufacturers, known as NABM, that would eventually become the International Sleep Products Association, known as ISPA. On a day-to-day basis, they were fierce competitors, but they were facing threats they couldn't stamp out on their own. It was time to find ways to work together. Most troubling was a sense of lawlessness contaminating the industry. Without standards governing size, construction, advertising, really anything at all, disreputable companies harmed the good standing and livelihood of honest producers. The NABM's purpose is much the same as ISPA's today: to elevate the image of the industry and its products, and to fight for manufacturers' common interests. From its earliest days, the association served as an advocate, arbitrator, communicator, marketer, troubleshooter, promoter, and peacemaker. And NABM didn't hesitate to criticize unprincipled manufacturers. In a 1924 article, the National Bedding Manufacturer magazine reported and exposed a producer who sold mattresses as new when, in fact, they contained components gleaned from old hospital bedding. Fines ranged from $10 to $500, and in some states, jail sentences. By the mid-1930s, law enforcement officials from 6 states convened in Philadelphia for the first meeting of the Association of Bedding and Furniture Law Officials, known today as the International Association of Bedding Furniture Law Officials, or IABFLO. In the 1940s, Ohio established the first laboratory for analysis and testing fiber content required for all new applicants. In 1963, AbFlow organized the Analytical Laboratory Committee, formulating the methods of test and procedure and what is known today as the classification of filling materials. Bill Kale and John McCormick were instrumental in the IABFlow Science Committee and are considered valuable resources with respect to terminology and testing methods used today.
So where is the federal government in all of this?
In 1914, Congress passed the Federal Trade Commission Act, and it was signed into law by President Woodrow Wilson shortly thereafter. The commission opened its doors as an independent agency, armed with the authority to root out unfair and deceptive practices. In 1956, the commission sued 3 different Down and Feather companies for what the commission, believed were false and misleading labels. Labels which had the potential to hurt both honest dealers and unsuspecting consumers. In 1957, the commission then filed suit against 11 more companies, alleging that the filling material listed on those law labels were false and misleading. By 1958, the Textile Fibers Product Identification Act was passed, specifically directing the commission to regulate the textile industry closely. The message from Congress was clear. Mislabeled product was not acceptable, and companies would be expected, under penalty of law, to properly label their textile products.
While ISPA and IABFlow have been constant promoters of uniformity, the reality is each state has their own set of regulations, presenting real challenges to companies engaged in the global marketplace. In 1994, ISPA created a manual to help guide bedding and upholstered furniture industry members through each of these state regulations. The ISPA Manual of Labeling Laws became a Bible for industry members seeking a comprehensive collection of information designed to help them navigate these various state regulations. In 1998, IABFlow approved the removal of the blank stamp block from the older style label, seen here with the date of delivery marked as December 13, 1976. For many years, this was the standard law label format. In 2014, IABFlow approved eliminating the date of delivery stamp on labels. Modern retail receipts provided the date of purchase at the time of sale. Since 2010, in collaboration with ISPA, Legal Label has taken over research, preparation, and management of the Manual of Labeling Laws, proudly creating the most comprehensive guide of all U.S. state and city law labeling and registration requirements. This is the 2015 ISPA Manual of Labeling Laws. This manual explains in detail the registration and licensing process for all bedding and furniture items, as well as each state's registration fees and what products require licensing. There is a section on the classification of filling materials as set forth by IABFlow, information on state mattress recycling initiatives, Canadian licensing, plumage labeling from IDFL, and most important of all, the format of law and flammability labels are depicted in various templates. We are Legal Label Incorporated. We assist industry members and help them navigate the confusing world of state and federal labeling requirements. Legal Label is honored to be the new authors and editors of the 2015 Manual of Labeling Laws. This manual is offered as a free benefit for all ISPA members or available for purchase for non-members online at sleepproducts.org. You can find this link and learn more about Legal Label, our services, and how the manual can help you by visiting our website at legallabel.com.